everyone. The Senate Judiciary Committee will now come to order. Appreciate everyone who follows us and watches online. Thank you for that, and for committee working so hard as we do. We will get started with opening the hearing on House Bill 2082. If we could have a bill brief from the reviser, Mr. Thompson.
Thank you, Madam Chair, and good morning, committee. This is Jason Thompson with the Office of Reviser Statutes. House Bill 2082 authorizes the Crime Victims Compensation Board to waive certain application time restrictions. It also adds certain children to the definition of victim. Section 1 is an amendment to KSA 74-7301 to define victim to include a person who suffers personal injury or death as a result of witnessing a violent crime when the person was 16 years of age or younger at the time the crime was committed. And then Section 2 is an amendment to KSA 74-7305 to remove the individual listing of sexual crimes and replace that with the term sexually violent crime as defined in KSA 22-3717, where all of those crimes are currently listed under one definition. The bill also allows the board to award compensation for mental health counseling to a victim of a sexually violent crime if the board finds there was good cause for the failure to file within the specified time period. And I will point out that this comes to you from the House, where it passed 125-0. I will stand for questions.
Thank you, Mr. Thompson. Committee questions for the reviser. I have a quick question, and where do the funds come from to pay for the mental health counseling?
Thank you, Madam Chair. Jason Thompson again with the reviser. I don't have that off the top of my head. I know the Crime Victims Compensation Board receives funding from some source, and I'm hopeful that Mr. Samaniego or someone else will be able to answer that for you.
Perfect. Right. I was just wondering if it was in statute somewhere in the bill or otherwise. So we will ask our conferee then. With that, then, we will ask the proponent conferee, Richard Samaniego, chair of the Crime Victims Compensation Board, who is appearing on WebEx. Please introduce yourself and welcome to committee.
Thank you. Good morning, Chairman. Chair Warren and members of the Senate Judiciary Committee. My name is Richard Samaniego, chair of the Crime Victims Compensation Board. Can everybody hear me okay? I better check on that.
Yes, we can hear you fine. Thank you.
Thank you. I appreciate the opportunity to provide testimony in support of HB 2082 on behalf of the board. As you know, the Crime Victims Compensation Board assists victims of crimes in Kansas with compensation for lost earnings and out-of-pocket medical expenses as a direct result of a violent crime. To answer your question that you just posed, the Crime Victims Compensation Funds are both federal and state funds. The Victims of Crime Act provides the federal matching funds, and the State Victim Compensations Fund provides the state funds. Those funds are primarily from penalties and fines from convicted offenders, and those mental health costs do come from that fund. And they are matched 80-20 by the VOCA funds from the federal level. I would be remiss if I didn't mention the dedicated staff of the Crime Victims Compensation Board that's through the Attorney General's office, who really are on the front lines of helping victims with their claims for compensation. HB 2082 simply provides the board with authority to waive the 2-year filing deadline for victims of sexually violent crimes who are seeking compensation for the mental health counseling when the board finds good cause for the failure to timely file. Generally, under the current law, the application must be filed within the 2 years of the date of the crime. And for certain child victims, the 2-year deadline does not begin to run until 2 years from the report of the crime. There are 2 narrow exceptions right now in the statute regarding the deadline, but therefore, if a victim's called to testify for a sexual violent predator commitment proceeding, or if they're notified of results of testing for DNA evidence. The board believes that there should be a little broader good cause exception in appropriate circumstances for victims especially when it's related to investigation delays or prosecution delays, which have been the claims that we have recently seen that we aren't able to approve. What happens a lot of the times is a trial could take a very long time. In a recent case, it was 2 years, and the claim is not filed until after that is done. The good news is the staff is taking note of these cases. So if there is an opportunity that we can help them, we will be able to with the passage of this bill. The key provisions of HB 2882 were passed in the House 125-0 last session, but were stalled and didn't make it to the Senate due to the pandemic. This year, the board supports inclusion of an amendment to that previous legislation that will add to the definition of victim by including children ages 16 and younger who witness a violent crime. All the studies suggest that that is quite a traumatic experience on a child, and mental health, access to mental health funds and services would be extremely beneficial to that, especially to the younger victims. So we support the inclusion of that to the bill, which was passed by the House this year unanimously. And I respectfully request the Senate Judiciary Committee's favorable recommendation of this legislation. I'd be happy to stand for any questions.
Thank you. Committee, any questions? Yes, Senator Wilborn.
Thank you, Madam Chair, and I think I know the answer to this, but I want a clarification. Thank you for being here, Mr. Santiago. Is there any retroactivity? Does it allow to go back on any claims previously filed?
Mr. Samaniego.
Thank you, Chair. Vice Chair Wilburn, yes, the board has discretion to reopen any claim as they see fit for if it's reasonable. And so if a claim is reopened, we would be able to apply current law to that claim.
Madam Chair, one more question, if I may.
Sure.
Next question is, who makes that decision to open up that claim?
Mr. Samaniego.
I'm sorry. Yes, Chair Warren, the board would make that decision. A claim that is filed, even if it is not eligible for a claim, is kept of record in our office. And so if it is put before the board can vote to reopen that claim. And if the current law allows, we can then consider that issue of mental health coverage.
Thank you, Madam Chairman.
Thank you. Senator Baumgartner.
Thank you, Madam Chair, and thank you so much for being here to testify for us today. My question has to do with, we see the addition of victim, the witnessing of violent crime when the victim was 16 years of age or younger, and yet they are not included in that exception of beyond the 2 years. Is that correct?
Mr. Samaniego.
The children are included in that exception, but not the witness of. My understanding would be that would be just for. Let's see here.
The exceptions are the human trafficking, the aggravated human trafficking, a sexually violent crime. Is that correct?
Yeah, under the current law, those are the only two narrow exceptions. In the future, if the Senate committee passes this favorably, it would allow the report coverage for the mental health services upon report of the crime. It would allow us to go beyond that deadline to consider for mental health coverage only those victims, including the one, and Jason can correct me if I'm wrong, including the ones that are now considered victims 16 years age and younger that have witnessed a violent crime.
So Jason, you will clarify that it does now include the 16 years or younger that witnessed?
Mr. Thompson, if you can reply.
Thank you, Madam Chair. Jason Thompson with the Revisor's Office again. It's a little confusing, and obviously the board knows these statutes much better than I do. I'm looking at Section 2, 74, 7305, and there's two different things that it addresses. Subsection B talks about compensation that can be awarded and has that 2-year sort of statute of limitations. That's not exactly what it is, but that's in essence what it is. And there are exceptions to that include victims less than 16 and the injury or death as a result of those listed crimes, trafficking, ag trafficking, or now sexually violent crime, which is a little broader than what's in B1 right now. Then there's subsection B2 that is about compensation just for mental health counseling. And that's the one that's focused on victims of sexually violent crimes. If the board finds there was good cause, for all other injurious conduct, there's the 2-year limit again. So essentially, I think I can confirm what Mr. Samaniego was saying, that there's a 2-year restriction here with some exceptions. And I don't know that most of your witness victims are going to qualify for that exception, but some of them might. So I think that's where the board is going to be sitting. And it seems like that's their policy choice that they're asking you to make. And if they'd like some changes, we can discuss those.
Yes, I agree with Jason's assessment. That's the main reason for the board.
Would you go ahead and identify yourself again?
I'm sorry, Chair. This is Richard Samaniego, Chair of the board. That's the policy issues that the board considers on a regular basis is when there is that guidance needed and a claim is filed. It'll go before us at our regular monthly meetings so we can consider whether it is appropriate to approve the request based on the current law and regulations. And we do have legal counsel that attends every board meeting that helps determine that policy guidance as well.
Madam Chair, I served for several years on the Domestic Violence Fatality Review Board, and one of the things that we knew happened frequently is that young children did witness oftentimes the violent crime of either a parent or a parent's partner murdering them. And yet, as young children, it often isn't until they start that psychosexual development in middle school age that the context of what occurred when they were much younger becomes an emotional and mental health issue. So I guess my concern would be, and oftentimes these small children go to family members, assume the guardianship for these small children. I'm not certain that that they would necessarily, within those 2 years, file a claim for future years, not having, in fact, that's what we heard from family members, because they're just trying to, those first 2 years, they're just trying to get through the crisis of the family loss and the brutality of what occurred through the domestic violence fatality. So I'm not certain that those family members would have the foresight to apply ahead of time, knowing that they might need that. So I am still a little concerned that that's not clearly carved out for them. They are clearly identified as a victim, but I think the younger they are as a victim, what will surface up will be much later beyond 2 years. So a 3 or 4 year old lost a parent through domestic violence would not necessarily understand the context of that until they were several years older. And that's when that mental health and that inability to form meaningful, positive relationships occurs and when the mental health assistance is needed. So a little concerned about that gap being there. Thank you, Madam Chair.
Thank you, Senator. Other questions for the conferee? I have a question maybe for the reviser. The 2 years sounds to me like there's a 2-year, it sounds similar to the 2-year statute of limitations that we have in the civil realm of civil procedure and bringing a civil claim. For instance, for personal injury or emotional harm, there's a 2-year limit on, you have to file your claim within 2 years of the date of the incident. So I'm thinking maybe that's where the 2 years to file your claim originated. I'm not sure if that's something the researcher, Natalie Nelson, can answer, or the reviser, or Mr. Samaniego, where the original 2 years came from. And it's been in statute for, I'd have to pull up the statute now rather than the bill, but just wondering if that 2 years was originally tied to, in Kansas, generally, if you've got a personal injury claim, it's a 2-year statute of limitations.
Thank you, Chair. Warren, this is Richard Samaniego. I don't know specifically the answer to that question, but the statutes do kind of have a lot of the language of the civil law because of there are some subrogation of claims and medical type reimbursement. So I would imagine that that's where it came from, but also just to make sure that we have that the proper evidence is recorded and to be able to make a claim. Based on the police reports and so forth. But I did want to elaborate on the previous questions of it is the intent of the board that if the victim, a child victim, witnesses and is eligible to be eligible for that good cause exception. I just wanted to make that clear that is the intent of the board. To make sure that they have access to those services. And part of the mission of the Crime Victims Compensation Board is to help with the education of child advocacy centers, law enforcement, other advocates, so that they know when these types of things occur, these reports are made, that they're given the resources so they can make the claim, and that'll preserve that in the future. So even if the child is not necessarily listed in the offense, there's going to be information out there to help them to make that claim, whether through counselors or others, so that they could know to go ahead and make a claim with the crime victims. And if for all of your, just for general knowledge, for all of you, if any constituent asks, we always recommend that if in doubt, just file the claim and we'll figure out if they're eligible or not.
Thank you. And it's an area of concern for the legislature and for the children who have been around this kind of behavior. Is there any, if it's not 2 years, there's no end date proposed in the bill, right? You could be in your 30s. I mean, there would be no ending to when you could file your claim. Is that right?
So
go ahead and identify yourself again, just for those listening.
I apologize.
Thank you.
I'm still getting used to the Richard Samaniego. So just so the committee's clear, there's the 2-year hard deadline, and that's when the date of the crime. But then there's the 2-year from the date the crime is reported for those certain exceptions of violent offenses, sexually violent offenses. So you're correct that it would toll until the crime is reported. So 2 years from the report of the crime. So it could go many years out.
Do you mean the report of the crime, the report of the crime to the police, or?
The report of the offense.
So there's a conviction and the offense is reported to the board, and then you would have, right now, 2 years to file your claim for compensation. Is that how it works?
This is Richard Samaniego. Yes, so if in most cases, you would have to do it 2 years from the date of the crime. But for
Okay.
sexual offenses primarily, you would be able to toll that until you report it, until it's reported to law enforcement.
Okay, I think we're using the word crime a little too loosely for conviction versus the behavior that might be criminal and might lead it to a conviction. So is it 2 years from the date of the conviction, or it's 2 years from the behavior that's reported? I guess I'm just not clear.
And this is Richard Samaniego, and that does confuse a lot of people at times because it has nothing to do with the conviction. Whether the offender is convicted or not, a victim can still apply. It's from when the crime is reported. And so when when the crime, well, let's say the police reports have that the crime was reported at this date, they have to file it within 2 years of that. But the exception for violent offenses, it's actually, it tolls until the time that they report it for those offenses. Does that make sense?
I'm going to review this further and have some other questions. Senator Gossage.
Thank you, Madam Chair. And I'm not sure if this question is for the reviser or for our conferee. On the fiscal note, on the second paragraph, it says that this 2082 would add children of 16 years or younger who have witnessed a violent crime to the definition of victim. And it goes on to say the bill would allow the board to waive the requirement for the mental health counseling to be filed within the 2 years of the crime being reported to law enforcement for victims of sexually violent crimes. My question is then, am I to assume that that means when it says victims of sexually violent crimes, that would include observing a murder or something like that may not be considered sexually violent crimes, but if a child, as Senator Baumgartner said, were to witness something like that, does this waive them from the 2 years, or are they still confined within the 2 years? I'm not quite seeing that in the bill, and maybe someone could point to me where that is.
Thank you. Mr. Thompson, the reviser, are you able to answer that, or Mr. Samaniego?
Madam Chair, this is Jason Thompson. I'll start, and then I hope that Mr. Samaniego will follow on as appropriate. So two things. First, that paragraph of the fiscal note is essentially the Office of the Budget's attempt to do a bill brief. So always keep that in mind. They sometimes aren't the most accurate. In this case, that's pretty accurate, actually. The provision that we've been talking about, and remember, there's two pieces. So there's the definition of victim, which is talking about violent crime, which qualifies you just for general crime victims compensation funds. And that's the 2 year restriction, and that's the exception for certain sexually violent crimes and trafficking and such. And that's for full compensation, not just mental health. And the extent of that compensation we kind of touched on, but I'll leave that alone for now. Then there's this mental health compensation that is separate. And right now it's 2 years as well, but there's a new exception that they're making in this bill for good cause when you're a victim of a sexually violent crime. So the combination of the definition of victim and the definition of sexually violent crime means that if you're under 16 and you witness a sexually violent crime, you would be eligible for mental health benefits, potentially, for good cause shown, even outside of 2 years. The potential gap that I think you have identified or are focusing on is if you've witnessed a violent crime that is not sexually violent, because sexually violent, that list in 223717 is what you would think of. Things like rape and sodomy and actually sexually violent crimes, not just murder, not just manslaughter, that are violent crimes. So essentially you've identified a policy choice. The board has kept it narrow to the sexual offenses and the sexually violent crimes as their statute currently is. If the legislature and the board want to broaden that to all violent offenses for good cause shown, that's a policy choice that it appears you could make, but I don't think you've been asked to make that yet, is my understanding. So I'll stop there. I think that's probably enough for me.
Thank you.
That brings up, that fiscal note reminder reminds me of my earlier question. Where does the compensation come from? That would be probably for Mr. Samaniego.
There we go. Thank you, Chair. This is Richard Samaniego. The funds for the Crime Victims Compensation Fund are, as I indicated, fines and penalties issued against convicted offenders. That goes into a state fund. The VOCA Victims of Rights Act, Victims of Crimes Act fund, the federal fund, matches those dollars 80-20. And so even the mental health everything comes from those funds. They can be all federal, state, a combination of the two, and that's how the fund is managed to maximize the matching funds. With regard to follow up on Jason's, that is exactly right. The reason it's narrowly tailored to the sexually violent crimes is that usually if somebody witnesses a violent crime, it's more likely to be done within that 2-year period because the crime date is an actual crime that has evidence and closer to that time period. For these sexually violent offenses, sexual offenses, a lot of the times nothing surfaces until much later. And that's where that's the distinction between the date of the crime and the report of the crime. Because many years later, the victim, especially a child, can reveal the crime and then it is reported much later. So the policy of the board has been to focus on those and find that good cause for accepting those because of the very unique and tragic circumstances that occur in those types of offenses. So I hope that helps to clarify the difference between the 2-year date of crime and then the tolling report of the crime.
Thank you. So when we're talking about compensation comes from fines and penalties, that would require a conviction for the crime first, right?
Correct.
Okay, and then we're extending the 2 years, sometimes there would not be fines and penalties collected because there would have been no conviction for a crime. Is that right?
Chair Warren, this is Richard Samaniego. Let me clarify the fund. The claim for each victim is not tied to their actual offender. All these crimes that are convicted go into one pot, which is the Crime Victims Compensation Fund. And then the claimant can then receive from those funds whether their offender was convicted or not. The board can determine they're a victim and then they get help. But it's not tied to the individual case. It all goes, the whole state's crimes and penalties of convicted offenders goes into one pot.
Sure, and that's oftentimes I would imagine that the mental health counseling would far exceed, the need for that would far exceed the amount of fines and penalties that would be related to the conviction. So it comes out of that pot because the fines and the penalties aren't matched up to what the mental health counseling component would be. And then we do note, again, looking at the fiscal note, that there would be an increase in claims and payments. So would it then be for the board? How does the board, how does the Crime Victims Compensation Board, how do they prioritize, or how do they decide, how much each claimant would be awarded? And it just seems, are there any parameters or standards that the public would be able to see how these are determined?
Thank you, Chair Warren. This is Richard Samaniego again. There's a maximum of 25,000 for any claim per claimant that is set in the statutes. Additionally, there's other limits that are set for mental health coverage. So mental health claims are maxed out at 5,000. There are some exceptions where you can go beyond that with findings, but generally 5,000 is the maximum that you can award for mental health coverage. And so the main reason for the focus of the board on that mental health services is just the clear research of the effects of addressing those mental health issues are just so beneficial, especially for victims of sexually violent sexual offenses, that we wanted to focus that attention on those individuals.
Committee, other questions for the conferee or the reviser? Was the bill brought to committee by the board, Mr. Samaniego? Do you know?
Thank you, Chair Warren. This is Richard Samaniego. Yes, in 2019, this was introduced by the Crime Victims Compensation Board, Attorney General's office, and so yes, to answer your question.
Okay, great, thank you. Okay, committee, any other questions? All right, seeing none then, thank you for your time and your testimony, Mr. Samaniego. Appreciate being informed again and brought up to date on this issue for these young children who are witnessing a violent crime, and it would be up to the board to determine what witnessing means and if they were included in a police report or whatnot. Was that something that the board would be looking at?
Chair
Mr. Samaniego? Sure.
Samaniego, yes, that is exactly right. We would review all the information that's submitted to make sure they are eligible and they do meet the policy as well as the eligibility requirements.
Okay, very good. Thank you for answering the questions. I know I had a lot of them. I appreciate that, and thank you for your time. And with that then, committee, I will ask, are there other proponent conferees in the committee meeting room or on WebEx? Seeing and hearing none, do we have any neutral conferees in the committee meeting room or on WebEx? Seeing and hearing none, do we have any opponent conferees in the committee meeting room or on WebEx? Seeing and hearing none, then we will close the hearing on House Bill 2082. And committee, we have next on our agenda a final action on bills previously heard. We are currently working with the reviser to determine what bills we can get ready to work together, if you will, to bundle together in an efficient manner for committee. We are also looking, I had heard yesterday that there were some additional House bills that would be referred to Judiciary Committee that I had expected would be read in this morning, and they weren't. But we will be probably getting those referred maybe Monday, I'm not sure. So please be prepared for next week that we will be meeting Monday through Friday, 10:30 to noon if needed, till noon. And we did get a new bill referred to committee yesterday that will be need to put on the agenda, and we will try to get through our work as expeditiously and efficiently and effectively as possible. For those reasons, then, I'd like to take a look and make sure we can be efficient with our work before we proceed working any bills today. And with then no other business on the agenda, we will adjourn and see each